Good afternoon. Thank you to everybody that's joining us today for the webinar. We're going to spend about the next hour discussing enforcement against private equity funds in healthcare and also going through the necessity of due diligence and compliance. I'm Mindy Sauter. I'm a partner here at McGuireWoods. I work primarily in the government investigations section, but do a substantial amount of work in the healthcare section as well. And I'm joined by Michael Elliott, who I'll let introduce himself.
Good afternoon. My name is Mike Elliott. I am a partner in the government investigation section here at McGuireWoods in Dallas, and I also do a lot of healthcare work, just like Mindy.
Good afternoon. I am Brett Barnett. I am a partner in the commercial litigation department. I work exclusively in the healthcare industry, and the vast majority of my practice is spent working on various fraud and abuse matters for private equity-backed healthcare companies. And then our remaining panelist is Michael Podboreski. I will let Michael introduce himself.
Good afternoon, everyone. Michael Podboreski. I am co-chair of the firm's False Claims Act team. That is where I focus most of my time, about 2/3 in the healthcare space and 1/3 in the procurement fraud space.
All right, well, we're going to jump into the presentation. This presentation is about the importance that the government has taken in the last several years. And the question being like why investors should care about fraud, waste, and abuse. That, unidentified and unresolved fraud, waste, and abuse, compliance issues, those issues can make what appears to be a good deal become a bad deal. The enforcement actions that we're going to be looking at clearly interrupt cash flow. They cause loss of contracts and customers. There's a distraction to the employees. As you know, like these issues often come about with subpoenas, and there are individuals whose jobs now become responding to those types of inquiries. These issues can also result in the prepayment review requirements or exclusion from healthcare programs. And as a lot of people know, the legal expenses and settlements related to these issues greatly exceed the profitability of an acquired entity. Even without an enforcement action, fraud, waste, and abuse problems can cause and have correlations to revenue changes post-acquisition, and that's through like audits. I mean, even if you didn't catch it up front, you could get audits on the back end and you spend your time answering certain types of audits. Recent government actions and statements that the government has made has shown that there's a heightened scrutiny on certain PE investments in healthcare. In December 2023, there's a bipartisan Senate Budget Committee spoke about negative impacts of PE ownership of healthcare entities nationwide. In March 2024, the FTC, DOJ, and HHS, they launched a cross-government inquiry into the impact of corporate greed in healthcare. And these are all buzzwords that are used to heighten the scrutiny on these types of investments. In June 2024, 11 states' attorney general voiced concern about PE negatively affecting healthcare in their state. There are certain states that are a lot more active than other states and take a very progressive role in this regard. And in June 2024, the DOJ announced its intention to use the False Claims Act to pursue PE firms that have invested in healthcare, and they're going to be investigating certain types of fraudulent conduct. They announced it in June 2024, which was last month. And the examples we have show that there is a trend in growing in this, and these examples that we're going to go through predate, obviously, June 2024. Example of recent settlements. One case out of the Southern District of Florida in 2019 is a key TAM case, which is most of these are whistleblower cases, which are key TAM cases where an individual files as a whistleblower, and then that case is investigated by the government, and it's either picked up, meaning it's intervened, the government intervenes and they stand in the shoes of the plaintiff, and sometimes the government decides not to pursue the case, but that doesn't mean the case is necessarily over. In September 2019, the DOJ announced a False Claims Act settlement with a PE firm, Reardon Lewis and Hayden, RLH. Patient Care of America and the PE firm RLH agreed to pay $21.36 million to resolve a lawsuit alleging False Claims Act violations involving a kickback scheme to generate referrals for prescriptions for pain creams and scar creams and vitamins, the government alleging that it was regardless of patient need. And these were reimbursed by TRICARE. TRICARE, this is right in the sweet spot of, if anyone has been in the healthcare industry, particularly a pharmacy, these compounded creams and certain types of vitamins were very high reimbursing items, particularly for TRICARE. So this scheme allegedly involved a bunch of marketers that were paid kickbacks to target military members and their families. And marketing is something we're going to get into later, because this is definitely a very important due diligence point whenever you're looking at a healthcare transaction. So the government was stating that the marketers paid telemedicine doctors who prescribed the creams and vitamins without having the proper doctor-patient relationships. And if you look at that just plainly, like, who should be paying doctors? It would conceptually not be the marketing arm of a group. So that's obviously a very important point to point out. DOJ also focused on two partners who served as officers of PCA, enabling RLH to exert significant control and oversight in the scheme. And what that is basically saying is that there are certain members of RLH who came into PCA after the acquisition of PCA and started making certain types of decisions that the government was saying was purposefully and very detrimental to the TRICARE program. This is a portion of the Medrano complaint. Basically, what it's saying, without going into reading it in detail, is that there was the company itself, the Diabetic Care RX DBA, Patient Care America, was a dialysis pharmacy. They did a lot of dialysis work. There was a decrease in the reimbursement on the Medicare side for those types of IDPN and IPN products. And so these individuals from RLH came in, reconstituted and kind of doubled down on the compounding section of PCA, and started to get into this scar and pain cream related to TRICARE, because TRICARE was reimbursing very highly for these types of products. Those patient-facing marketing issues are complicated, as well as the relationship between the marketing group and the telemedicine doctors was something that the government was particularly not thrilled with, and pursued this case for the settlement that was announced in a press release, which is normal course of business for DOJ. It'll settle a False Claims Act, and they'll release certain types of information. And this was a $21.36 million to resolve those false claim allegations. And
the next one that we see, sorry, Mike, the next one that we see is a settlement that came down in November of 2020. It involved a company named Theracos that was formerly owned by Johnson & Johnson from 2006 to 2012, and then was purchased by PE group, the Gores Group. Before the Gores Group even came in and did the acquisition, Theracos was actually engaging in off-label marketing of a cancer drug. That cancer drug was FDA approved for use in an adult population, but Theracos was off-label marketing that particular drug for use in a pediatric patient population. The interesting thing about this settlement is that all of this off-label marketing started when Johnson & Johnson owned Theracos, and the Gores Group came in and did not have anything to do with the rollout of the marketing, didn't have anything to do with the types of communications that were initially put out there to physicians about how to off-label use this to the pediatric practice. But the government came back in and said, even though they didn't have involvement in the way that the practice started, because they came in and they didn't stop the practice, they were also on the hook. This settlement ended up with Johnson & Johnson agreeing to pay $10 million and the Gores Group agreeing to pay $1.5 million. They really focused here on the inclusion of the way that the Gores Group decided to hire a former Theracos employee and put him as the CEO. That employee continued to engage in that improper off-label, and the Gores Group didn't take any action to stop it. Go on to Alliance.
Excellent. So Alliance and Ancor in July 2021, DOJ reached a settlement agreement with Alliance, which is a national EEG testing company based in Texas, and Anchor Holdings LP, a Texas-based private investment company. So EEG testing is tests electric activity in the brain. They're brain scans. And the allegation was that Alliance was inducing physicians to order the company's testing services by providing kickbacks in the form of free test interpretation reports that were provided to the clinicians who were not neurologists, who weren't really qualified to necessarily review and interpret the EEG test results. But by getting the report, they would go ahead. This would enable the physicians to go ahead and bill for the interpretation services. Anchor allegedly learned of the kickbacks during their due diligence review prior to their investment in Alliance, and the government claimed that this caused the submission of false claims by allowing the conduct to continue. So under the terms of the settlement, Alliance agreed to pay $13 million and Anchor agreed to pay $1.8 million to the federal government. And then there were another about $500,000 paid to states under Medicaid programs. And again, this was also a qui tam suit, and whistleblowers here walked away with almost $3 million in relator share. We've included the press release here, as well as sometimes the government in the press release will attach the settlement. This is the Anchor settlement agreement, and this is what's called the cover conduct section, which describes the conduct that is at issue. And this talks about their having committed the due diligence but not altered the conduct, and this contributed to the submission of a false claim.
All right, so now we go to a more recent 2021 settlement that happened between South Bay Mental Health and HIG, a PE firm that acquired it. This is a little bit like the one that I spoke about the last time. There were problematic compliance issues that existed within South Bay before the PE firm ever came in and did the acquisition. This settlement is interesting because it points directly to the diligence that was done. And when they look at the diligence that HIG did, they realized that HIG was provided with information that showed that South Bay was employing mental health professionals that did not have the appropriate licensure or were not being properly supervised. And so the diligence period that happened, there were multiple documents that were turned over to the private equity group that showed them that they had this particular compliance concern. And after the acquisition was complete, there was a continuation of allowing these same employees or even newly hired employees to practice within the mental health facility without proper licensure. This is actually a settlement that I think took everybody a little bit by surprise. It was a $25 million settlement between the two, South Bay and between the private equity firm, one of the largest settlements that we've seen. There was a lot of press that revolved around this settlement because of its size. And when we look at the complaint, which is featured here in these next couple slides, they really point to the due diligence, specifically what was provided and handed over to the private equity group during acquisition that they did not pay attention to and take any action to correct. And so this one was a meaningful settlement to read. It's something interesting to go back and look at if you guys want to take a look at this webinar and the slides after the fact, because it really points to what people need to be paying attention to in these type of acquisitions. Mike, I think you might be on mute.
Sorry about that. This next case is related to Insys Therapeutics, which deals with the fentanyl subsys, like the subsys, which was like a spray onto the, like a lingual spray related to fentanyl. the reason why this case is interesting, there's a couple of reasons. One, it's interesting because it involves obviously a PE group, Bell Health, that had a controlling interest in this Linden Care pharmacy. This was also a mail order type pharmacy where individuals were prescribed this substance. And if you look, and I'll go here to the complaint, if you look at the number of cases that are signed on to this, the reason why this is interesting is because of the importance of dangerous opioids and how states have taken a concerted interest in trying to protect their population from what they consider to be an invasive issue of opioids into their communities. And once you get into these types of situations where not only the government, but also all these state AG's office are signing on, you obviously have issues. One, the federal government's on there for the Medicare money, and then state is on there for all of the Medicaid money. So this is interesting because at the end of the day, the government was going to extract a large settlement from Insys Therapeutics related to the substance, but in actuality, they ended up not intervening against Bell Health. So in not intervening against Bell Health, essentially what it did was leave that up to the plaintiff's attorneys, right? The plaintiff's attorneys have every right to proceed with the case without the government's intervention. Obviously, a government intervention is important for key TAM attorneys. They want that. And it seems in this case that they got it to a certain extent, but there was disagreement about whether the government and all those states wanted to envelop into their investigation and settlement Bell Health. So they settled it, but this plaintiff's firm did not go away, and they continued on. And what the government does in those situations is that it basically sits back and says, well, good luck with your case, and we'll come knocking once you come up with a settlement, which is exactly what they did. They just kept pushing, and they were very persistent about filing amended complaints. And what they did was really highlight, interestingly, sections of public statements that Bell Health made about their abilities as an investment group in this particular space. And so when they settle the case for $9 million, you can go look at the complaint. And here they basically talk about, and specifically call out certain sections of press releases about Bell Health's significant experience as operators and investors, particularly in the pharmacy space, make them an ideal equity partner for our company. And they also talk about its deep experience in healthcare operators and targeted sectors. So in that type of affirmative advertising and just press release information, not only will the government use that, because they have used that in the past to show and try to impute some type of knowledge and control, but plaintiff's attorneys who are left on their own in a case that's not intervened, that will be something that they will be interested in trying to kind of push that narrative that either Bell Health knew or whatever PE group knew or should have known, and just look at their statements imputing pure knowledge and familiarity with the subject matter on their behalf. And so this was a settlement with the manufacturer of Subsys, which we've all heard about, the fentanyl crisis, and how this was also provided via mail, and it increased problems in certain states. And then they pivoted over to the investment group Bell Health when it was not intervened in.
Thanks, Mike. And so the last one that we have before, I think Mindy and Mike are going to go through a little summary of just what we're seeing with these recent enforcement actions, is Oliver Street doing business as U.S. Dermatology Partners. And this one is a little bit different than the other cases we've talked about today, in that this was self-disclosed conduct. This was conduct where the current operators, or the operators at the time of the settlement, discovered AKS violations and Stark violations on behalf of some of the former executives of their predecessor management company, and disclosed the conduct to the government. And we'll talk about the benefits of that and how the government incentivizes that later in the presentation. But in short, what was going on in Oliver Street, our U.S. Dermatology Partners, was US Sturm was a management company that was doing add-on acquisitions. And in a handful of those add-on acquisitions, senior management was inflating the purchase price of the non-clinical assets of the PC, of the goodwill. They were inflating what the PC's purchase price was in exchange for continued referrals post-close. And that conduct, for anyone that operates in the healthcare space, knows that is problematic under the AKS and the Stark Law, something that you would see commonplace in other industries, obviously cannot do in the healthcare industry where we can't incentivize future referral streams. And the government accepted the U.S. Dermatology's self-disclosure of this conduct based off of the settlement amount, which is still a sizable amount of $6 million in restitution. You can see, though, that it's not a 2-for-1 or a 3-for-1 settlement based off of the single dollar value. Instead, it's approximately 1.5. And so it goes to the concept that we'll talk about later about self-disclosing, identifying cooperation, can buy you credit with the government and also can reduce the total amount that you have to pay as part of any settlement. With that, I think that we're going to go into the next slides, which are the roundups. And so Mindy and Mike, I'll turn it back over to you.
Thanks, Brett. So just in summarizing, kind of going back to what Mike said in the very beginning, is that the government is interested in these types of transactions, and their interest is only mounting. These settlements have increased not only in value, but in number over the past couple of years. And we've learned a lot just by taking each one of them apart and looking to see what the government's interested in. The Johnson case and also the South Bay case are both very interesting because they're highlighting the fact that the private equity firm does not have to have any engagement in the unlawful activity to be held responsible for it. All they have to show is that at some point during the diligence, they learned what was happening and they didn't stop it proactively moving forward. And if they find that, then there is definitely enforcement action on the horizon. You know, we see in a couple of these other ones where the PE groups come in and they actively place people on the boards or in roles of employment where they continue the fraudulent conduct and they just drag it through from the old entity into the acquired entity. And obviously those settlements are the ones that we see that are a little bit more aggressive because they're playing an active part in that type of fraud. But we don't see these enforcement actions slowing down. We only see them picking up as the government gains interest. And so what we want to talk about in these next two parts is the due diligence that's necessary for companies as they acquire healthcare entities, and also the compliance that we think the government needs and wants to see throughout these acquisitions. So the importance of diligence. Private equity roll-ups and investments in healthcare have their own sweet spot that really needs to be paid attention to. The healthcare regulatory landscape is incredibly difficult, and the rules are often hard to understand and confusing to people that are even working in these type of healthcare entities. And so we really encourage drilled down due diligence whenever a private equity group is coming in on an acquisition. Specifically, we want to look at the structuring, the investment structures, particularly if there's any position ownership. We know that the government takes a very hard line on those types of structures. And anytime we have mixed revenue stream models. Marketing activities, which we'll talk about a little bit more in depth moving forward. Marketing is typically where we see a lot of enforcement action. It's where we see a lot of healthcare companies get themselves in trouble because of what is happening in the marketing of their actual entity. Billing and coding trends are something that really have to be looked into in depth. Audits, what audits have been done, what type of billing and coding that particular practice is engaging in, and is it in line with other practices in the same field, and are they doing any type of upcoding, bundling, any type of those issues? Have they had audits in the past? Unexplained or poorly explained outflows of money. You really have to look at every direction of what money's coming in and how it's going out. We're seeing growing risk areas, definitely with telemedicine, ever since COVID has come around and allowed a relaxation and more telemedicine to enter into the space in healthcare and play a really big part in healthcare. We're seeing a lot of enforcement action there. Tech plays with remote patient monitoring. We're also going to see a lot of new interesting AI interventions with healthcare. And then also private equity valuations and analysis, making sure that we get those fair market values done appropriately, and we're doing appropriate analysis on each level of the healthcare entity itself. Those are the major topics that government is looking at. Due diligence difficulties, we often run into a problem with just general due diligence requests, asking for specific contracts or specific types of financials, but not really drilling down into the relationships that cause the most amount of problems within healthcare entities. Looking at the relationships with the physician investors, like we spoke about, and also with the marketing groups as you bring marketers in either as a W-2 or 1099. So we have to make sure that the due diligence requests that are being made during these acquisitions aren't just general due diligence requests, but that you really get down into the relationships and also the billing and coding and marketing issues that affect healthcare entities the most.
So this is, kind of an example of any type of basic structure of a business. And we do this in particular when related to certain types of acquisitions. And this can go for any type of acquisition, whether it be a laboratory, a pharmacy, a dermatology practice, a pain practice. And whenever you start to do this, you're asking, how does this company work? What are the company's relationships? And how is it that they make money? And what are some of those problems that could arise? And so once you get the basic structure and charting down, and these are all the people and all the groups who are involved in this, what we try to do, and this is just an example, is point out where some of these problems can arise that are traditional issues that you don't see in traditional due diligence. And so if we start at the left of it, at the left of this chart, it's you have the laboratory, that's the acquisition target. They have a relationship with a tech contractor. The question, and all those boxes in red are specific questions that we usually like to really delve into, because that's where we have seen problems arise, because those relationships either are problematic from the start, or they are not described correctly in the paperwork, or they're described a certain way in the paperwork, but in actuality they're different, and you only find that out through really drilling down. So that relationship between the laboratory and the tech contractor, is there a fair market value? What type of compensation are we talking about? Is it a per click compensation? Those are very specifically related to anti-kickback concerns. Then you have the tech contractor potentially with the telemedicine company, right? There's always this kind of relationship between the two. What is that relationship? Is there a co-ownership? We want to see the licensing agreement. Do they subcontract any of this work out? And you look at the telemedicine company itself, is there an irregular compensation for these individual doctors? Is there a high turnover? What does the employment tech services agreement really say? And what is it that they're doing in relation to this? And, little things like high turnover are very relevant, because when you look at specific telemedicine companies in particular, we have had a significant amount of experience dealing with doctors who have, worked in certain types of telemedicine groups and then left in a month, and then they end up getting a subpoena, and they leave because they're like, this really wasn't what I signed up for. And then they find out during this process, they're one of 50 doctors who have done this and have walked into this problem. And that's indicative with that type of high turnover of something that is potentially problematic. And then you have down lower, you have the marketing group, you have the relationship between the laboratory and the marketing group. What are the marketing group arrangements? What is the fee structure? Is there a fair market value to it? What type of services are actually performed? And then you have this other box at the bottom talks about the marketing group and Medicare beneficiaries. And if you think back to the original case example we have with the RLH group, that increased their profits by, I think it was 300%, because they shifted from diabetic to compound medications, those groups, those marketing groups was like directly facing towards Medicare beneficiaries. Like, how did they find these people? Where do they find these people? And then what is the makeup of these beneficiaries? Like, are they from, what's their zip code? How is it possible that they found so many people from Naval Station San Diego? How, if it's TRICARE, or, and a lot of these obviously, are TRICARE issues, but if you have a Medicare beneficiary, like, are these individuals all located in, or is there 15% of a certain nursing home involved in this? How are they getting into that nursing home? What's their relationship to that nursing home? I mean, all these questions are very important that can really give you some color into how this works, how they make their money. Because when you're looking at it as an acquisition, you're like, this really seems to be a good deal, and it seems like they really have an increasing ability to earn more money. But how are they doing it? Because once it ends, like, it's over, and you don't want to walk into that problem, because what you have valued as something does not maintain that value, right? And then at the end, you have like the relationship between the individual physicians and the laboratory. Like, who are these physicians? What's their medical board history? What is their utilization? Like, what is it exactly that they are ordering from the lab? I mean, do they have a wide arrangement of physicians, or is it just one specific group? Like, trends like that are important. And the thing is about trends is that they are empirical, and the government has become very adept at looking at certain types of data analysis and data analytics, where they are running into, like, they're going to run a certain code, or they're going to run a certain physician, or they're going to run a certain location, and then they're going to find out what they believe to be an outlier. And then you're kind of running up against problems that are evidentiary problems that show potentially that show like maybe somebody's intent or inferring intent. And so this is just a schematic of any type of situation that we look at and try to break it down so that we're walking into advising correctly in certain situations. And so, in the previous example, a lot of documented relationships to a group performing due diligence access points to identify potential compliance issues. You have to understand the regulatory issues surrounding these relationships. That's very vital. And while not all potential problems leave a paper trail, the more tailored you make your requests, the more likely you are to uncover potential issues. And you have to know what questions to ask in that due diligence process.
So we've talked a lot about broad strokes on the importance of really drilling down in due diligence. Mike just hit some of the highlights, and I thought it would be helpful to give some examples of when we go in and due diligence on a healthcare private equity acquisition, there are very specific things we look for. And one of the things we do is we always look at the compliance program. What is it supposed to look like? And then start to take it apart and ask for pieces that should exist in any company that you are trying to acquire. One thing that always proves to be very fruitful is asking for the compliance hotline reports and corresponding resolutions. That tells you right off the bat whether or not they're actually even taking a compliance hotline report, which they should be doing. And if they are taking that report, are they getting it to a resolution? That can give you a really good snapshot of the historical issues that any company has had if they are documenting those issues and also resolving them. And as important, it can also tell you if the company is not doing what they're supposed to be doing in terms of taking hotline reports, paying attention to any potential problems that bubble up. Employee files, that's always a good place to look because it shows you whether or not they're checking the exclusion for OIG and state. And it also goes through the licensure verification or whether or not somebody's had board actions. In the South Bay case that we talked about earlier, if they had gone through employee files and checked licensure verification, they might have figured out a little bit more of who needed to be licensed to do what and who had what appropriate licensure. Ancillary agreements are always something that are important to look at, including any lease arrangement. Compliance program, every compliance program should consist of compliance notes. You want to see every one of those compliance notes and see how frequently they are recording any type of compliance issues, how thoroughly and how they're addressing. Billing and coding audits are always something that we dig into, and I always think that it's really helpful in certain practices to ask for, if it's a physician's office, we want to see your super bills. We want to see how you're marking each and every visit and how that's corresponding to what you're billing, to see if you're getting that translation made from the doctor's office to the billing company, and then run those codes down and make sure that those codes are appropriate, that they're not upcoding and that they're not bundling. In terms of marketing materials, this goes right back to Theracos. In Theracos, they were off-label marketing. They were putting materials out there, encouraging physicians to utilize a cancer drug in a pediatric population. It's really important to look at any entity's marketing materials, either their online presence, the marketing materials that they leave with physicians' offices, what labs, pharmacies, any type of marketing materials that they're utilizing. It's important to look at those, and also the marketing relationships. We talked about this a little bit, and we're going to go a little further into that next, but the marketing relationships, not just the current ones, but also the historical marketing relationships are incredibly important to look at. A little bit more into the marketing activity. I think that it's really important to focus on what type of sales force they have. What is the entity doing? Are they doing active physician-facing marketing, active patient-facing marketing, which is always a concern of the government. The government does not necessarily like it when you go out and actively market to the patients. So that has to be done in a very specific way. And passive patient-facing marketing can be problematic as well. The most important thing is to get a good understanding of what type of marketing they're utilizing, how they're training their marketers, and what types of materials the marketers are putting out into the world. Resisting the urge to compartmentalize marketing. A lot of people will do that. We're a healthcare entity. We're clinically based. We're focused on this. The marketing is kind of over here siloed. When you silo marketing off like that, it tends to cause a lot of issues within the company because there's not the oversight that you need when you have people out there pitching your product. There's always a discussion back and forth on a W-2 sales force or a 1099 contract. Those types of marketing relationships, whether they're W-2 or 1099, need to be thoroughly vetted to make sure that they don't draw any activity by the government. We always say, keep your friends close and your marketers closer. The training and oversight and documentation of marketers is so incredibly important. You have to have oversight into what they're doing once you place them into the world.
So important aspects of due diligence related to cash outflows that you're going to need to look at in any due diligence. Like, there are usually three major approaches used by acquisition targets to conceal what could be considered illegitimate payments. One, you conceal the existence of the payment itself, so it's not able to be, or you try to make it unable to be detected. You disclose the existence of the payment, but disguise the recipient, because the recipient that could potentially receive it would be violative of an anti-kickback issue. Or you disclose the existence of the payment and the recipient, but misrepresent the nature of the payment. Like, have some type of contract that describes what it is that's being provided, and if that is the case, it's necessary to run to ground whether that is actually being done for the value paid. And so mechanisms to detect illicit payments, other than the one I just mentioned, is like, a fair market valuation of this arrangement, an analysis of the contract or ownership, like really drilling down into what and who owns these other types of groups, and then a review of the sales, employee communications. This is always critical because people make very loose statements when they're texting, and sometimes even when they're emailing. And a lot of these investigations that we've discussed, rely heavily on those types of communications. And just like whenever you're writing and anyone's writing an email that you have to double check it, like, that's the same thing that should be done when you're communicating via text. But that needs to be something that is a compliance issue. You can't talk loosely about these issues, and there's definitely a training element to this for any type of marketing group, because there is this theory of that your boss, meaning the group that's in charge, is responsible for the actions of their employees and sometimes even their contractors, and that gets imputed back to the group itself. And And so you want to really find out what it is these individuals are talking about on the ground. And that is, we found that to be very critical.
And so turning gears here a little bit, we wanted to talk about some of the new guidance that we've seen from the Department of Justice on acquisitions and specifically disclosures related to or conduct relating to and arising out of an acquisition. And so last October, Deputy Attorney General Lisa Monaco, as part of a speech and presentation, talked about a new, which she referred to as a safe harbor in the context of mergers and acquisitions. And so unlike a safe harbor that we typically think about in the AKS space, this was a more broad pronouncement of safe harbors and immunizations from criminal liability and responsibility for ongoing fraudulent practices that were discovered either prior to a transaction or in the time period immediately following a transaction. So it is not a safe harbor in the sense of you are immunized from civil liability. It is that there will be a presumption of criminal declination for conduct that could otherwise be considered violative of criminal law. So in our world, violations of the anti-kickback statute it is a criminal statute. We often see it prosecuted civilly, but it is a criminal statute. And so compliance with this guidance in safe harbor leads to a presumption of declination on a criminal investigation. And the mandates for this, and I think Michael's going to talk a little bit about the practical effects and takeaways, but the mandates for fitting into this safe harbor are that, one, it needs to be disclosed within 6 months of the acquisition closing. So it could be conduct that was learned pre or post acquisition. They look at the date of closing, and it's 6 months from the date of closing. And then two is that that remediation needs to be taken and occurred within 1 year of that closing date. And so in most of the instances in which, in a fair number of instances in which we're involved in internal investigations, we usually are disclosing and remediating simultaneously. It's like we are submitting a self-disclosure and we are planning to remediate therein. Like we've made the decision. Here they are contemplating a two-step sequence of, one, you flag it, you identify the conduct, and then you have a second 6 month period, up to a 6 month period, in which you can take all of the steps necessary to remediate and unwind it. And so a little bit different than how we typically handle internal investigations that lead to disclosures, but still a tried and true concept for how you identify the conduct and then take steps to remediate it. And then part three of the requirements are that you cooperate. It is effectively a self-disclosure, where in a self-disclosure, it's not that you disclose piecemeal facts and then pull back the curtain or pull up the curtain again. It's that you're going to cooperate on an ongoing basis with the government, answer any follow-up questions, because the government does have an ongoing priority and focus on individual and high-level executive liability. And so you can't use the self-disclosure process as a way to hide and protect executives that are engaged in wrongdoing or try to deter the government from following on to any of its other action items or priorities that they've targeted over the past 5 years.
Yeah, and to add a little context and color, this is part of a broader context, which is Deputy Attorney General Monaco, who's really sort of like the corporate crime and compliance czar within the Department of Justice. She's been on a huge kick of trying to incentivize self-disclosures. And this is one aspect of several speeches and policies where she has focused on self-disclosure and really trying to incentivize self-disclosure and compliance as well, which we'll talk about in the next section. In terms of this particular policy in the safe harbor, it's not entirely new. Going back to the 2000s, the department has issued opinions, and individual components within the Department of Justice had policies, formal or informal, that misconduct identified as part of an acquisition that was appropriately reported within a reasonable amount of time would not be prosecuted. What Deputy Attorney General Monaco is trying to do here in her speech announcing this and in the policy itself is to formalize it across the Department of Justice and create certain metrics, the 6 months and the 12 months, 6 months to report, 12 months to remediate. And and then formalized. In that way, it's formalized and standardized. Like a lot of safe harbors, it's a double-edged sword, right? So if you comply with it, the presumption is you will get the criminal declination. That's good news. The not great news is now if you do not comply with the 6 and 12-month requirements, if you do not self-disclose and report, the presumption may very well go the other way, right? So now that they've formalized the safe harbor, companies who come in a couple years later and self-disclose or don't self-disclose, get caught red-handed a couple years after the fact, there'll be less sympathy there and less tendency to listen to the argument that, but it wasn't us, it was a pre-existing practice. We just acquired this problem. So while this was presented as a carrot, it is very much both a carrot and a stick here. And if the safe harbor requirement, much like the AK, I think most of our audience is familiar with the AKS and the Stark, much like the safe harbors and exceptions there, if you don't comply with them, dot the I's and cross the T's, you may be looking at sort of a per se violation. And then turning to the next slide, and I previewed this, Michael and Mindy are going to do a deeper dive on compliance. I just want to emphasize and sort of give you and again, I'm based in the DC office. I came from DOJ a few years ago, and Mike and Mindy were in the U.S. Attorney's Office in Texas. I have a bit more of a DC perspective. I can tell you across administrations, there's been a real emphasis over the past 10, 15 years on, when companies are accused of misconduct, they will, as part of their investigation, DOJ will review the company's compliance program. That is not new, but this administration in particular has really bolstered that and emphasized that it is going to drive their decision-making process in terms of what they're going to charge the company with or what they're going to demand from the company in a settlement process. In other words, if a company that has committed wrongdoing, if they have an excellent compliance program and the wrongdoing was something that slipped through the cracks or one individual was coloring outside the lines, that'll be treated a lot differently than misconduct at a company that had a paper compliance program. So this administration, through their emphasis on self-disclosure and emphasis on compliance and the policy we just saw, the safe harbor we just saw in the last slide was actually announced by Deputy Attorney General Monaco last year at a conference of compliance officers. And she led off the conference by saying, I really want to empower you. That is what this administration is trying to do. And they're trying to align incentives so that a company that invests in compliance will have sort of a twofold return on investment, right? One, you will reduce risk. So there'll be less wrongdoing. There'll be less cases from DOJ, less settlements and verdicts to pay. But two, even to the extent, you can never reduce risk to zero. There's always the chance of some wrongdoing. DOJ will view that wrongful conduct very differently at a company that has a very good compliance program than a company that has a paper compliance program. So with that, Mike and Mindy will have a little more in-depth view of what makes for a strong compliance program.
Thanks, Michael. So to Michael's point, what's really important is making sure it isn't just a paper compliance program. Anytime you go through diligence and anytime you look at a healthcare company, you should expect to see some hiccups. Healthcare is difficult. Regulations are tough to always navigate appropriately. The important thing is what you do when you realize that there is a problem, how you handle it, how you document it. But the flip side of that, and to what Michael said about making sure that you can show that you have an effective compliance program, is making sure that you're also paying attention to the good efforts for a compliance program. So when you look at a potential acquisition and you're looking at a company, you might see some wrongdoing. You're going to go through all of that. You also need to focus on the positive compliance efforts. Do they have policies and procedures? Do they have a compliance officer and compliance notes? Are there utilization reviews and marketer oversight? All of these issues are issues that most compliance programs or compliance officers will tout that they have, but you have to really look behind the statement and see if that's actually true. The compliance officer is the most important part of the entire compliance program. They are the person that hears all of the complaints, determines how to handle those complaints, how to resolve those complaints. And the most important job that they have is documenting each and every problem that comes their way or that they uncover through auditing. One thing that we hear all the time when we're talking to companies in either building their compliance programs or doing their diligence is they say, oh, we really have not had any problems. Maybe just a few here and there. And we say, okay, well, show us what documentation you have that shows that you have done audits and everything was fine. And they always say the same thing. Well, everything was fine, so we didn't document it. If you ever have to answer questions at the government level, it is not going to be enough to say, we did audits and everything was fine. You're going to have to be able to document and show that and say, every quarter we go through and we do an audit, and this audit, and you run through all of the issues that were found and how they were resolved. And finding the issue is important, but making sure that you include a resolution to the issue is just as important. And so we look at compliance programs and we look at compliance officers and we see, is there a volume of notes? Are they not just documenting when they have a problem, but also saying, hey, this issue was brought to us. We did an in-depth discussion and investigation into it. And we found that there is no fraud, waste, and abuse concern. That's a note that needs to be drafted every single time there's a favorable investigation that's resolved. Volume of these compliance note is important. The detail that goes into them is also incredibly important. You really have to have a resolution. It's like going back to the compliance hotline that I was discussing earlier. If you have a compliance hotline and you have people that are calling in and you mark that you had a call and this was reported, but there's no investigation or resolution noted, you have not closed the loop in a way that the government wants to see. And so the key to these compliance programs is making sure that you're noting and documenting each and every single thing that you're doing. One of the things that we always talk to clients about is they say, oh, we were approached by this particular group and they wanted us to do business with them. But then we started to do the diligence on them and we started to kind of ferret through it. And we just realized it wasn't a very good idea. They weren't the type of group that we wanted to work with. And we always say, did you document that? Did you put in writing how much effort you put to track all of this information down and the business decision that you made because you are so focused on compliance not to work with them? And so those types of compliance efforts are incredibly meaningful. Like Michael said, if the government comes in because you have a discrete problem and they see that that is in fact a discrete problem because on every other level, you are attacking compliance at the highest and greatest, level, then that's going to play well for you in the way that that's resolved.
So, to Mindy's point about documenting, for example, like a deal that didn't go through, like that's a valuable piece of documentation to look at because it really goes straight to intent. And once you are able to counter, eventually, if there's a situation that comes up and the government's position is like, well, you guys really didn't care about this, and you don't have that evidence to show of your positive intent in trying to do this correctly, then it's passed, and you really are putting yourself in a hole. So I think really a lot of this, and the term that we use is you need to make your good evidence, right? You have good evidence of the compliance work that's being done, and it has to be documented because if it's not documented, it didn't happen. And so when we go into groups and start doing this due diligence, we see what I call the good, the bad, and the ugly. The good is that people and groups have adequate policies and procedures and some type of structural analysis. The bad, you see substantial deficiencies in the quality of the compliance notes, like Mindy was talking about, no marketer oversight, a compliance officer who is not engaged, or some lack or inadequate utilization review. And then the ugly being that the government pursues enforcement actions and they compartmentalize issues and really hyper-focus on perceived problem areas. And that is where making your good evidence comes into effect in order to counter that approach. Because there are issues that will inevitably be problematic, but they cannot infect everything. And once you are able to make your own good evidence, and all you're doing is recording what you actually did, that's incredibly valuable. So you can try to compartmentalize that. The other thing about a strong compliance officer that we say is that once you have a strong compliance officer, like you're essentially it's a very strong relationship. I wouldn't call it a marriage, but it's something akin to a marriage because that is a person who knows a lot of information, and that is a person whose job it is to keep the group on the right track, and that is not somebody that can be marginalized in the operation of the company. And so what Mindy was talking about the importance of a strong compliance officer is cannot be overstated. Mindy also kind of touched on this about saying we hear clients or acquisition targets and they say we don't have any problems. We're so committed. We just don't have any problems. And that approach it's two things. One, it's not plausible because if you're in the healthcare industry, there's no way to find your way through some of these regulations and contradicting guidance without running into problems. And so if this group has not found any, then I don't believe they were looking. That's not always 100% true, but a lot of times it is true, which is why it's important to do that due diligence. And then apart from that, it is strategically ineffective. That the enforcement authorities, they want very simple cases, unburdened by regulatory nuance and complexity. That is a prosecutor's approach. You're not inclined to pick up something and move on something that has a lot of other issues that go against your leading argument. And so it's not effective because if that's their approach, they have not created that evidence to show that they have done the work. And it allows the government to build a case or their notion against what we consider to be like a blank canvas. And then you're really playing catch up in that regard.
So that really wraps up. There's a couple of slides left that just continue to talk about the importance of documentation. It wraps up the webinar that we have planned, but we did have a question that popped up on the Q&A that I wanted to address, and I'll address it briefly and then let Mike and Michael and Brett add in anything that they want to. But the question that was posed is, what is the degree of risk for a board member from a control versus non-control voting perspective, i.e. investor came in as a minority investor as opposed to full control PE investor? So I think that the risk is less, obviously, if you don't have that active participation in the company. It's not completely erased, but when you look at if you go back and you look and read through the documentation on the settlements that we talked about, if you think about like Gore, they had, I believe they had board members that were they had members of the PE group that were placed on the board that were actively making decisions and actively involved in the day-to-day running of the business. And so when you draw investors in and you put them in a place where they're aware of the company's decisions that are being made and being acted upon, and they're involved in it. So there's a difference, in my opinion, between being aware of it and being involved in it. Both of those things, I think, present a lot of risk. For a minority investor that's not involved in the day-to-day running, doesn't have the knowledge, obviously I think that risk is much less than what I previously discussed. And Brett, Mike, Michael, if you want to add anything to that.
Yeah, no, and I think echoing Mindy's statements, I think there's also just a different decision tree that we need to follow through on liability under the False Claims Act. It is a fraud-based, it is a high-to-prove standard. But very few cases ever get to a decision by a court or even active litigation. The vast majority of these types of cases get resolved before a lawsuit is ever unsealed or before you're ever filing like a motion to dismiss or getting into discovery. And while the government doesn't have unfettered discretion and they can't go after, or they're not going to get approval to go after innocent individuals, they do have initiatives to go after and go up the chain and to look across and to try to really broaden the number of targets that they have, and they can extract leverage and pressure at different levels of board involvement and management, knowing that government investigations are expensive, they're time consuming, and they're almost inherently bet the company cases for litigation. And so that's all to say is that whereas you might have very strong arguments on liability and defenses that you could use if this were to move into litigation, the government is very much aware that the overwhelming majority of cases never get to that stage and that you're likely to settle beforehand. So they might take a more aggressive approach with who they view as being in the ring of possible culprits or liability at an outset of an investigation or a civil investigative demand.
All right.
Yeah,
Michael, go ahead. Sorry.
Yeah, just very briefly, those are both good points. But just to push back a little bit, the general trend here we've been trying to emphasize is that the DOJ, and particularly this administration, is really gunning for private equity, particularly in the healthcare space. That said, their priorities don't undermine the elements of a False Claims Act claim or a criminal claim. And one of those elements is knowledge or intent. And for the False Claims Act, it's recklessness or deliberate ignorance. For criminal claims, it's willful and intentional misconduct. So if theoretically, if you're a minority investor, you had no idea the company was paying kickbacks to physicians, as an example, your investment may suffer, but to come after you individually, it doesn't matter you're a private equity investor. The government still has to prove knowledge and intent amongst the other elements, and that does not change by them prioritizing going after private equity in the healthcare space. So wanted to tie that bow.
All right. We are over the hour. Thank you guys, everybody, for tuning in. I just want to make sure everybody knows that this there will be a recorded version that will be posted to the website, McGuireWoods website, within 24 hours of this webinar. So thank you again. We appreciate the participation.
Thanks, everyone.